Compliance is a profession where people work tirelessly to make the world a better place. And there are hundreds of amazing and inspiring women who have helped the field develop into what it is today. Great Women in Compliance is part of the Compliance Podcast Network as they talk with women in compliance who are making a difference.
Welcome to the Great Women in Compliance podcast with Hema Lomax and me, Lisa Fine. We are sponsored by Corporate Compliance Insights and produced by Tom Fox of the Compliance Podcast Network. Today, I'm speaking with Karen Woody, who is a professor in securities law, financial regulation, and regulatory crime at Washington & Lee. She is also a member of a number of professional organizations, including the SEC Historical Society, which is a nonprofit archive of the history of federal securities regulation, the National Adjudicatory Control Council of FINRA, and the Academy of International Financial Crime Litigators. That's a collaboration between private and public sector litigation professionals and the Basel Institute on Governance. And our listeners may know her as part of the Everything Compliance podcast with Tom Fox. Thank you so much, Karen, for being here. And so like me, you started your career practicing in corporate law firms. However, unlike so many of us who did this and moved on into in-house roles, you became an academic. So can you talk a little bit about how you got into compliance and how you got to your current role in teaching?
Sure. I'm thrilled to be here, by the way. I'm a huge fan of this podcast, so I feel very honored that I get to be on here with you today. This is great. So my path to academia was a bit of a winding one. I started in a large law firm right out of law school. And so that is how I fell into compliance. I was doing really large sort of multinational cases with defending essentially multinational companies, often in huge FCPA cases. And so that work naturally lends itself to being also a compliance type role, because after we would do these large internal investigations, often would negotiate with the government about potential fines or resolutions. The other part of that work, and truly inherent with the potential resolution, is to show a robust compliance program that the company now had set up. And so we were really involved in doing that work from the outside counsel role. Obviously, we worked with in-house counsel and others to set that up, but that became part of the work I was doing at a law firm right out of law school. And so because of that, I've been a little bit compliance adjacent or sometimes squarely in compliance when I was doing that work, and then continued to do that for really the 10 years that I practiced law. And then eventually I realized I probably didn't want to stay at a firm forever. So I thought about in-house roles. I thought about going to the government, but I had been an adjunct professor during my time at the firm and really enjoyed it. It was one of those jobs where I feel like when I went to teach, I would leave the classroom with more energy than I went in with some days. And I just thought maybe this is a good path and avenue. Candidly, I also had 2 young kids at the time, and the work-life balance in academia is drastically different than that in a law firm. So that was another appealing factor. And so sure, I decided to go on the academic market. That involves a lot of writing, and publications is really the currency of academia. So I had to do that even while I was practicing, which was hard, but got it done. So I then transitioned to teaching. And I started actually teaching at a business school, which was an interesting shift because I'm teaching more principles-based. It did dovetail with a lot of the work I'd been doing at the law firm because I was dealing with people who were in business all the time. But then about 6 years ago, I came back to teaching at a law school, and that's where I am now.
So one of the things that you were mentioning is while you were at the law firm, you were also planning this next step or considering it or contemplating it. Not that you were necessarily walking out the door, but I think it's important for people to realize that this was a longer process than just deciding one day and applying for academic positions.
That certainly is the state of the academic market now. People expect you to come with papers already written and having thought through this. And to be fair, I'm a little bit of an outlier that I practiced as long as I did before going into academia. There are people who right out of law school know that's their path and make a lot of headway in that way. I scraped my way in for sure, but I'm glad I've landed where I did.
And I think it's great. I also think it's really important for lawyers and others when they're training to become lawyers to get some of that practical view, because sometimes when you get out of law school, you can really spend a lot of time talking about how you interpreted case law. And then something gets put on your desk, no matter where you are. And there's like real people and real problems and different kinds of things that are involved when you're actually doing it as opposed to analyzing it for law school.
Oh, 100%. And honestly, I call practitioners my old colleagues all the time because by definition, if that is on your desk, there probably isn't a case that answers the question immediately. It will be a new iteration of the law. And so you guys are the cutting edge of what's happening in law. And so in practice is where the law is really being made, I think. So
one of the things that you have been speaking about and writing about recently is about the role of victims in structured agreements with the government. And one of the most recent examples is Boeing and where their DPA and then the later Plea agreement. So I wanted to start with your take on that process and then talk about the victims a little bit.
Sure. I actually think the Boeing case is both a great example and also a not great example. And I'll explain why in a minute. But sure, the Boeing case obviously is a terrible case. There are terrible facts and terrible things happened. And so there's a set of very clear victims in the Boeing case. And by that, I mean there are people who passed away when these failures on every level of Boeing resulted in two horrific plane crashes. There's some clear victims in this situation, and that I think makes it ripe for creating sort of new ways to think about how we handle victims. But the reason Boeing in some ways is not a great example is because there's not that many other, hopefully at least, there won't be that many other white collar cases that is so one-to-one about what the harm actually is to a diverse number of people. And I'll maybe get into that in a second. But sure, in Boeing, they have a very significant fines. It ended up being over $2.5 billion over all told. $500 million of that went directly to a victims fund. I think I've seen somewhere it's between $1.5 million each victim might end up receiving as a result of this, and victims' families, obviously. Victims were able to have some say in this, especially even in front of the judge when they were going to decide if the judge was going to approve the settlement agreement or not. The victims had asked for tenfold that. They wanted the DOJ to bring a $25 billion fine as opposed to what ended up being about $2.5. And so I say that they had a say. They obviously had their voices heard, but they didn't get nearly the amount I think that they had asked for. And then the bigger problem, and what I was been recently discussing with others and others even internationally, is even just structurally, what is the role of victims in these particular processes? In theory, the victims aren't really heard because the structure isn't set up for that. This is the government finding a company for something. And obviously victims are included in the scope and the set of facts, but likely the victim's redress will be through maybe a civil suit. There'll be some way that the victims will bring their own wrongful death or whatever type of other lawsuit that isn't maybe part and parcel of the criminal proceeding. Obviously, when we think about criminal proceedings, victims do have a say, but that's often in things like sentencing and how big should this fine be. So they do have some way to have their voices heard, but they're not really seen as a true party to the case or to a necessary function of settling these cases. And so that was what we wanted to discuss with, like I said, in this group of folks who are from around the world who had takes on how that is done in even other countries. And the short of it is that's not uncommon for most countries to have, especially when there's not a guilty plea. There might be a non-trial resolution like a DPA or an MPA. The victims have a say. They're able to be heard in various avenues, but it's not that they are necessarily considered party to the litigation or anything like that. It's interesting, in the United States, we have things like the Mandatory Victim Restitution Act, which means that there are certain claimants that can be eligible for the restitution that can come out of even these criminal fines, which we saw here. There are statutes that are attempting to protect victims, but how much they can say in these DPA and PA negotiations is still being sussed out. And so the reason I mentioned that Boeing might not be the greatest example for other cases going forward is because if you think about a typical maybe FCPA case and the issue is corruption, how you pinpoint even who the victims are is really the biggest and first question. is the victim or are the victims the citizens of the corrupt country who are not receiving maybe the full benefits of whatever contract someone has negotiated with the government? Others would contend that the victims are the competitors to that contract who were not able to land the contract because they were playing by the rules and not bribing a government official. Some would say it's the shareholders of these companies who then receive these huge fines. So there's so many potential people that feel some sort of harm after this. And so even getting our arms around who the victim is in typical white-collar cases is really the first major question.
And also, figuring out who they are is one thing. And then the second question is, regardless, how involved should they be and should the subject matter be a part of that? And I think that must be a real challenge as well. But maybe Boeing is at least shining a light on this.
It's such a clear answer about who the victims are. However, I was talking to someone about that, and they were like, victims, do you mean shareholders? And I was like, whoa, that's a little callous. But maybe not untrue. This company now has certainly a shareholder, there'll be a derivative lawsuit, of course, on the backs of this. The management failed to do their job or to certainly have a compliance program potentially in place to catch this. And as a result, shareholders took a hit. The company took a huge hit. So sure, that's a more callous type of argument, certainly, than what I think is the most obvious set of victims, but also not untrue.
And the third thing I was thinking about is, given what it's done to impact travel and other things because of what they've done, many people have, especially over the summer, the slower down of being able to get the parts they needed, the airlines, there's so many victims, but those are not, for most of us, the victims are people who lose people. But in a lot of cases, as you said, it's not as clear as that.
Right.
If it wasn't that this put a spotlight to it, but it was just regular travel delays, would anybody notice?
Right.
No. And for you, though, what direction do you think that it should go? Do you have any thoughts on what is a good path to improve if we need to improve?
I do think, like I said, and other statutes help allow for a path for victims and have a very interesting definition of victim, someone who's directly or proximately involved in this criminality, and that there should be equally a robust civil solution for the private plaintiffs who are harmed here. I guess I wouldn't want to supplant that and to think that maybe that would be foreclosed if the victims received something in a criminal settlement, that they certainly would be able to seek as much redress as they could as for being the private plaintiff. So I do think there's merit to both. But acknowledging that I do think the victim's ability to be heard and to have some compensation, especially when these fines are so astronomical, that does seem to be one of the faster tracks, maybe to allow them to get some restitution.
Yeah, especially if a company is going to try to tie it up in litigation for many years. Right. This forces it at least right away so that so that different plaintiffs and different actual victims get the opportunity to at least have something in the meantime because something bad happened.
Yeah.
And it's not the ones that every so often we get a class action settlement for some sort of suit related to, $3.70 because something on Netflix. I don't know if that's actually even real, but it's that kind of thing. Caveat to those listening, I just pulled that out of thin air. But yes, what about, also, and the last question I have about this is we talked a little bit about international, like similar but different, but, how are those victims being able to be heard in these cases, like particularly in Boeing or other ones? And do they get other avenues of relief from their governments or help? How do we deal with something like that?
Depending on the country, they have different, in fact, I put a little plug to the Academy of Financial Crime Litigators, which I'm a member of. They had a great white paper that we just put out this summer that had a similar discussion of this in 6 different jurisdictions, the U.S. being one. So it was Canada, UK, Germany, Switzerland, and France, mostly Europe focused. But so it's interesting to see the little tweaks between them. And so I don't know as much about the sort of nitty gritty of the processes for each one of these, but you can tell that there's been a lot of thought about where we see more avenues for victims. For instance, I believe it is in Switzerland, has an avenue to have the victims not approve the settlement. So there is some sort of, you also need to have the victims be on board with what the settlement is between the prosecutors and the defendants. So there are little nuances here and there that I do think in certain cases give victims a much more robust role, and then certain jurisdictions where it's less. It's hard to say if there's some universal idea. I do think even this concept of the DPA, MPA, non sort of procedural type resolutions is exported a lot from the U.S. I think was one of the first movers on those types of settlements. And how victims play when you're not in a more formalized setting maybe is yet to be seen in other jurisdictions.
That's great. Thank you. I'm going to turn the topic over a little bit. This actually, when we were talking earlier this week or last week, we started talking about internal controls, which to me is not only perfect timing because of my life and we're collaborating with them, but we just had a panel discussion about that with everyone's, your good friends as well as mine, Matt Kelly and Ellen Hunt, and one of my colleagues from Pearson, talk about the importance of that relationship. So then our conversation went in a sort of a different direction, talking about the Solarwinds decision and internal controls. We had to go academic somewhere on this part as well. So can you talk a little bit about the case and the ruling and your take on it, just to give people some background?
Sure. Yeah. So the SolarWinds case was decided in July, and the gist of it was SolarWinds had, first of all, it is a sort of cybersecurity type company, and they had a breach they had their own cybersecurity incident. And it was one that was very well known. It was this huge, what was called a sunburst attack that was done by state-sponsored hackers out of Russia. So a lot of major issues because this affected SolarWinds clients, who included major Fortune 500 companies, government institutions like Homeland Security and Energy Department, Treasury, all these things. So it was a major, huge issue. And so they are dinged, obviously, in a number of different ways, but also by the SEC for an internal controls charge, in addition to fraud and other things about statements they'd made about how great their cybersecurity software was and that kind of thing. But the thing I wanted to think about, the thing I really spent a lot of time thinking about, was this idea of the internal controls charge that the SEC levied, or I guess allegation they had made. Because the internal controls provision, first of all, is the one they use here, 13B2B, which I know is very nerdy to get all the way into the name of the statute, but it is the reason I raise it is because it's couched in the FCPA. So it's part of the books and records, internal controls that we see required in even mostly in the anti-bribery space. But the SEC in recent years has really used that without having any link to a bribery issue or a bribery charge. They've just used an internal controls charge, which they did here under SolarWinds. And what was surprising is that the court dismissed that provision. There's certain things in the SolarWinds case that will continue, but the majority of it was tossed by the judge in this huge, 100 and some page decision. But the judge was saying, hey, internal controls has to be linked to an accounting provision. This is an accounting provision, internal controls. And the issue here was a cybersecurity failure and a lack of internal controls around your cybersecurity. And he said, this is too far apart to link that to an accounting thing. For that reason, it was rejected by the court. I found that interesting. I was a little miffed that this came out in July because I've been writing a paper about it for a long time that was arguing this point, which is we're pushing the internal controls enforcement beyond, I think, its initial intent. That said, this is why it's a little bit academic. I think practically this should be allowed to go forward. But academically, you're using the wrong statute if that's the case. And if there's not a statute, maybe we need one or a reg about this. Because, we do all care about cybersecurity internal controls, but we really are trying to fashion this into a pre-existing statute that really runs the risk of exactly this, of the court finally being like, this is not the thing you can charge them with. That's essentially what happened. They said, this is not close enough to an accounting control because that's the meat of this particular statute. And so they threw it out. So that, again, I'd already been working on it, I'd already been thinking about this, I'd already had a little bit of a critical eye toward how this particular provision had been used by the SEC in a handful of recent cases. And cybersecurity felt like even more of that, especially because really what this is nearly a strict liability, you didn't have controls, so we're dinging you. it's hard to say. We had pretty great controls. It's one of those, if the thing happened, you obviously didn't have a control for it. So it feels like there's no real defense even, and which to me feels, especially when you're in new areas, that I do think SolarWinds had some pretty clearly bad facts here. But I know I'm wearing a little bit of my defense attorney hat. I'm just, what should they have done? If we've never seen an attack like this before, what control shouldn't they have? So I just, that's where I was thinking and where my mind was a lot this summer. And then this case came out. So I thought that the judge obviously had the same idea that I had. So that's the background and where I've been thinking about the SolarWinds issue.
It's interesting. I think a lot about in terms of internal controls, even the ones we do have are in finance. They originally started in the whole SOX controls, and people are trying to limit them to that sometimes. And what is material and what isn't. So one of the things is a financial internal control fails and leads to bribery. How would that, I feel like that might be closer, but on the other hand, that's something where I find this interesting from a practitioner standpoint for them to say, if it's for people to be able to say, wait a minute, if this doesn't fall under an internal control, maybe something that as you were talking about, adjacent, using the term adjacent earlier, is this internal controls adjacent if there's no materiality? And that I think is what I think about it from a practical standpoint, that it concerns me about where that line would be. It's good that we get some definition for it. I agree with you. I think the government agency, part of the responsibility is to put things under the right categories. If not, have a new category. Businesses have to adapt all the time. But is there a potential for a slippery slope? What do you think?
Yeah, and that's where my argument was headed, which is now everything is an internal control violation, regardless of what happened or what maybe was actually even prevented. If some little thing could slip through, then we have an internal control charge. We might not have a more substantive charge of whatever happened. For instance, I wrote a paper a long time ago about this in the FCPA context. Things like the BHP Billiton case about what they had done in China during the Olympics. And they had these records about who was coming to the box at the Olympics that they were hosting, and they had to fill out who their guest was and who they'd given any kind of trinket or any sort of gift to. And some of those weren't fulsome in terms of what they filled out, or some gaps or something. And so even though they had made this sort of effort to be tracking who was there, where our gifts and entertainments or risks are, the SEC took those little forms, counted them as a record for books and records purposes, and then dinged them for not having more robust internal controls of checking all those. It's not untrue. There is maybe some foot faults here and some things they were doing wrong, but it became a really big sort of enforcement action under the FCPA for this exact type of activity that to me seems like a stretch of, man, we have a lot of things we've lined up, tried to do all these things correctly. A few people didn't fill out a few of the lines on these forms, and here we are now facing significant FCPA liability risks. So that's where I started with this, of saying, listen, there actually were no bribes and there was no accounting. No one is, moving money around. This was simply a form about who was showing up. And that counted as a lack of a control. And to me, it just felt like we're pushing the ball pretty far on these type of enforcement actions. And then SolarWinds is that in a different direction, which is that the scope of what the controls are about might now be much broader than just accounting provisions.
And I think when you're talking about the China example, it just came to my mind. For all of the things, and hopefully now it would be seen differently, because I think things have evolved enough, because the last thing you want to do is say, okay, great, my lesson from this, from failing to have a control, is we'll just do a bunch of checking the box. So then at the end of the day, you end up with a bunch of people who have perfect books and records that aren't necessarily reviewed or accurate or logical, just so that you can stay out of trouble. And I think for me, I always am talking to people about the importance of trying to do the right thing, making ethical decisions, and that there are always tough questions and mistakes. This is the kind of thing that you see if people truly are trying to do the right thing and have good intentions. I think that, again, it's not quite like victims, but that matters. It matters.
Yeah, I agree. And that's a better way of saying what I was trying to say by last thing about. They are trying to do the right thing. Everyone is trying to check all the correct boxes and do what hopefully is in compliance with the law. And so these little sort of footfalls feel like creating a pretty broad amount of liability for people who are trying to do the right thing. They're not trying to hide stuff or move money here and there. So that's where I was coming from. So I agree. I think you said that even more succinctly.
Well, I wouldn't go that far, but I think of it much more from a what am I living through every day than a what does the court decision say? It's how do we apply this and be effective?
Yeah.
And with that, obviously, you've talked a lot about how you're thinking about things from an academic standpoint, right? And we talked a little about it at the beginning of if somebody wants to move into academia, we talked about publishing and writing, but what steps would you advise? And even more broadly, it's got to be a challenging path. And if you decide to do it a little later on, especially after time in a law firm, what would you say to a woman or anyone, particularly women who want to make that shift? And how do you stay resilient when the challenges, because they're going to be some, come up?
Sure. It can sometimes be an idiosyncratic process to find your way into teaching. There's not sort of a super clear path unless that path was set way back when you were in Yale Law School.
Exactly.
I would say be really curious. Think about what your clients are facing and how that's tricky given the context of what laws are up against. That's how I think I started. I'm like, this law isn't working, I think, the way it was intended to work, or it's being applied in a different way. And I'm seeing that through these cases that are right on my desk. So that's how I started writing about things, because sure, you want to solve the client's problem that's sitting there in front of you. If you extrapolate it out, you say, this is going to happen over and over, like something maybe should shift. And so that thinking into like how this applies in a broad way, I think is what can be the nucleus of a paper or of a even policy paper, white paper kind of idea that is, I think, the foundation of the academic and scholarly research, which, I mean, honestly, you're doing a decent amount of that even while you're practicing law. It is research and writing. So it's not necessarily a different skill set at all. It's just, again, not particular to a specific client. I would say, yeah, find some things you're passionate about, things that you were frustrated about, didn't go your way or not, and think about what would be a shift in the law or some way to think about that a different way. And yeah.
About how do you manage to stay resilient when you're going through the process and some of the challenges? Because you've done all these things, and these are not easy areas to practice in, being a defense lawyer or coming into this. How do you best get some of those challenges in the process?
I think you can't take it personally, honestly. It is a really hard field to break into. Like I said, if you weren't groomed for this from years and years before, you're probably even at a law firm, honestly. And I do think academia, I hope that there is now a much broader sort of acceptance for people who come from a lot of different paths. And those paths aren't just, I got a PhD in economics or something else, or clerked only at the Supreme Court, that kind of thing. It is people appreciate the merits of being a practitioner, which you and I talked about at the beginning. It's really important for students to talk to people who are actually doing the work and have done the work. And I do think it's just worth recognizing that if you have to try and try again, I had to try for years to try to figure out how to get one of these jobs, that, yeah, it's just know that there will be a lot of rejections on the way, because that's just the nature of it. And it's also sort of a relatively small number of positions too. So there's that issue as well. There's only a certain number of law schools, only a certain number of positions in those law schools. And so it can sometimes be tricky to land that plane, but I would for sure encourage it. I think it's one of the most rewarding professions I can think of. I've really enjoyed it.
And there seem to be adjunct opportunities out there as well. So I would say that get you in there, at least to start thinking that way. Well, Karen, thank you so much for spending time with me and with the GLIC community, and on behalf of the Compliance Podcast Network and Corporate Compliance Insights. Thank you so much and have a great day.
Thanks, Lisa. It was great to talk to you.
You too.
Thanks for joining us for this episode of Great Women in Compliance. We hope you'll join us in honoring the great women in the compliance field by subscribing to this podcast and leaving a review.